Welcome to everyone to our webinar on the 2024-2025 Sentencing Review, which is brought to you by the Garden Court Chambers Criminal Defense Team and the Howard League for Penal Reform. My name is Thalia Mirage. I'm a barrister at Garden Court Chambers, and I am your chair for this webinar. Just a little bit about myself. I have been a lawyer for over 20 years, and I'm a duly qualified member of the Jamaican and English bars. My practice is predominantly criminal defense and civil liberties. In my crime practice, I defend in serious crimes, and I also represent victims in inquests and public inquiries. And I am also a trustee of the Howard League. Now, we have a wealth of speakers with us this evening. I will start off by introducing our first speaker, the Right Honorable Lord Phillips, who is a retired law lord and past president of the Supreme Court of England and Wales. Lord Phillips was called to the bar in 1962 and took silk in 1978. He was appointed a judge of the Queen's Bench Division, sitting in the Commercial Court. In 1999, he was elevated to the Court of Appeal, appointed Master of the Rolls in 2000, and Lord Chief Justice in 2005. Lord Phillips was appointed as Senior Law Lord in 2008, and oversaw the transition of the House of Lords to the Supreme Court in 2009, when he became the court's first president. Between 2014 and 2018, he was the president of the Qatar International Court and Dispute Resolution Center. We also have on our panel Professor Nicola Padfield, King's Counsel Honors, Emeritus Professor of Criminal and Penal Justice at the University of Cambridge. And Nicola is one of the panel members of the Independent Sentencing Review. So it's really a privilege and an honor to have her with us this evening. She's a fellow of the Fitzwilliam College, and she's retired from the university in October of 2022. Just a little bit of about Nikki's background. After her first degree at St. Anne's College, Oxford, she went to Cambridge to study criminology, and she was called to the bar in 1978. Her teaching and research have covered a broad canvas in criminal law and evidence, sentencing and criminal justice, and more generally. She sat as a recorder, as a part-time judge in the Crown Court from 2002 to 20. Nikki, you're going to have to correct me there because there seems to be something missing from that. And I don't know how many years you sat for as a recorder, but you were appointed honorary silk in 2018. And I have to say that as a practitioner in Jamaica, I came across your articles, which I found very interesting. Our next speaker is Andrea Coomber. She's Chief Executive of the Howard League Center for Penal Reform. And Andrea was appointed silk, honorary silk in 2022 for making major contributions to the development of law in England and Wales. She joined the Howard League in 2021, having previously worked at Justice, Interrights, and the International Service for Human Rights in Geneva and the South Asia Documentation Center in New Delhi. Andrea is also qualified as a barrister and a solicitor in Australia. Our other Garden Court speakers are Stella Harris, who is also a member of our criminal defense team. Stella has significant experience representing those accused of murder and serious violence, and with alleged connections to gang activity, where there is admission of bad character associated with association evidence and unhelpful stereotypes are successfully challenged. She assisted the Howard League in making submissions to the DPP regarding the reform of the CPS guidelines on charging in joint enterprise cases with adversely and unfairly impacted young people. Their suggestions were incorporated in the final guidance submissions on charging in cases of joint enterprise. And Stella also has an established practice representing women charged with murder and serious violent offending. And that, I know, will feed into Stella's presentation to us this afternoon. And our final speaker is another member of our crime team here at Garden Court, Joanne Cecil, King's Counsel. Jo combines a mixed serious crime and public law practice with criminal justice-related judicial review and civil litigation in the civil liberties sphere. Jo has an expertise in strategic litigation and acting for interveners. She has been instructed in every significant test case at the appellate level concerning juvenile justice in recent years, resulting in significant changes to the law. She was instructed by Just for Kids in the Joint Enterprise Supreme Court case of Jogi, and Jo is a member of the Equality and Human Rights Commission's panel of preferred counsel. So today's discussion will delve into the scope of the sentencing review, sentencing inflation, and its impact on the prison population. Our speakers will cover topics including reconceiving custodial sentencing, resourcing non-custodial sentencing, and tackling the unique challenges women and young people within the criminal justice system face. And we're also going to be touching a little bit on minimum terms. So over to you, Lord Phillips.
Thank you very much. And I'm going to give you a little history by way of background to our discussion. As you heard, I was called to the bar in 1962, and I'm going to talk about sentencing in the first 10 years of my practice at the bar. Now, this isn't something that I can do from memory. I practiced at the Admiralty Bar and had no real connection with crime at all at the time. But I don't remember there being any controversy at the time about sentencing, let alone there being any problem with finding places for people in prison. So I went to the Middle Temple Library to do some research. And to my surprise, I couldn't find anything at all about sentencing in the 1960s until, thank God, I struck gold. And Gold was the first book, I believe, that's ever been written about sentencing by David Thomas, who was then a young lecturer at LSE. And what he did was to analyze every decision on an appeal against sentence between January 1962 and October 1996. And from these, he was able to identify the sentencing policies and principles of the Court of Appeal. And these differed markedly from those to which we are accustomed today. In his introduction, Thomas comments that it was, I quote, the general policy of successive parliaments when creating and developing the legislative framework of sentencing to leave the widest latitude, both in general and in particular, to the judiciary, who will operate the system. Happy days. And this policy was not to change until the end of the 20th century. The Court of Appeal, and implicitly the sentencing judge, imposed a two-phase approach to determining a sentence. The first stage was of crucial importance. Should the sentence be individualized, turning on the circumstances of the individual offender, or should it involve the application of a sentencing tariff of imprisonment whose length reflected the gravity of the offence? The individualized sentence would involve an alternative to punishment directed to rehabilitation of the offender. The primary decision of the sentencer involved a choice between two different objects of sentencing. The first was rehabilitation of the offender. The second was deterrence. The Court of Appeal generally referred to a tariff sentence of imprisonment as a deterrent sentence. Remarkably, the court hardly ever referred to punishment or retribution. The Court of Appeal made it plain that its preference was for an individualized sentence where this was possible. This was because rehabilitation of the offender was both in the interests of the offender and in the interests of society as a whole. There were two circumstances in which the court found it impossible to impose an individualized sentence. The offence might be so serious that the need for a deterrent sentence precluded having regard to the individual circumstances of the offender. Or there might simply be no alternative to custody available that would offer a prospect of rehabilitating the offender. The approach of the Court of Appeal is evidenced by this passage from an appeal in 1963. In the case of a young offender, there can hardly be any conflict between the public interest and that of the offender. The public have no greater interest than that he should become a good citizen. The difficult task for the court is to determine what treatment gives the best chance of realizing that object. That realization is the first and by far the most important consideration. In an appeal in 1966, a youth of 19 had attempted to rob a petrol station attendant. The trial judge had held that the offence was so serious that a tariff sentence of 3 years' imprisonment was inevitable. But the Court of Appeal varied this to an individualized sentence of borstal training. Of critical importance in providing the court with a viable alternative to imprisonment was a probation order, the most common alternative to imprisonment, and that depended upon the probation service, because the probation order placed the offender under the supervision of a probation officer for between 1 and 3 years. And the probation service at that time had a very high reputation. In addition, the court had a wide power to require the offender to comply with such requirements as the court considered necessary for securing the offender's rehabilitation. These could include a requirement of residence in a supervised hostel. And so the existence of this dedicated and competent probation service was essential if probation was to work. A particular problem in the 60s, as it is today, was the recidivist, the persistent petty offender. Parliament had attempted to deal with this by providing for the imposition of an extended sentence of preventive detention, essentially keeping such offenders permanently locked up. But judges had simply declined to impose such sentences. Instead, the courts were increasingly subjecting this category of offender to probation orders. 3 linked features of sentencing policy in the second half of the last century are peculiarly striking. The first I've already mentioned, the lack of any emphasis on punishment. Tariff sentences were called deterrent sentences and justified on that basis. This wasn't very logical. It was taken as axiomatic that the longer the sentence, the greater would be the deterrent effect, and that the more serious the crime, the longer the prison sentence that was needed to deter it. The fact remains that courts paid at least lip service to the need to deter and not to the need to punish. The second feature was an apparent total disregard of the interest of the victim of the individual crime. There was, of course, no provision for victim impact statements, and the Court of Appeal judgments do not suggest that the impact of the crime on victims was of any relevance to the sentence. On the contrary, it appears to have been a matter of general policy that the court was bound to disregard particularly adverse consequences of a crime that the defendant had not intended or foreseen. This is particularly evident in the case of 2 motoring offences. One was causing death by dangerous driving. An element of this offence was that the defendant was driving so badly that he should have foreseen the potential fatal consequences of his driving. This made the offence so serious that a tariff sentence of imprisonment was almost inevitable. However, the maximum sentence was 5 years imprisonment, and even in a bad case, 2 years tended to be the norm. In the case of careless driving, any death that resulted was considered to be a mischance that the driver couldn't reasonably have foreseen. The consequence was that, as a matter of principle, the sentencer could not properly have regard to the fact that the careless driving had resulted in loss of life. The normal sentence would be a modest fine. Contrast that with the recent extension of the maximum sentence for causing death by careless driving to life imprisonment. Today, punishment that reflects the consequence of the crime is the primary object of sentencing. Individualization is out. The tariff is all important. Now, the relative merits of the policy when I started at the bar and the policy today is a matter for debate, perhaps debate this evening. A quite separate matter is the merit of the remarkable inflation of sentence lengths that has incurred since the start of this century. This is now generally recognized to be the result of statutory intervention by government, and I'm quite certain that that will be a topic that we shall discuss this evening.
Thank you, Lord Phillips. Shall we move on to our second speaker, Professor Padfield?
Thank you very much indeed. You introduced me as a panel member of the review, and I think I have to start by saying I am not speaking as a member of the review, and don't try and read between the lines for some great secrets about where we're going, because I hope I won't share any, and if I do by mistake, I'll probably have it wrong anyhow. So we're not there yet. You will probably all know that we have just released the first part of our report, which is an analysis of what's gone wrong, really, as I would see it. And Lord Phillips gave us a bit of a wonderful history lesson just then. It was also Lord Phillips and his fellow Lord Chief Justices, plus Sir Brian Leveson, who produced, I think, a rather good Howard League sponsored report, was it 6 months ago now, about the problem, and I'm going to get my students to do a compare and contrast of the two reports to see which is better in terms of undergraduate essay. I won't comment, but there are some really interesting issues, of course, which came out of the Lord Chief Justice's paper, and I hope out of the Independent Review's paper. The main factor is obvious, that lengths of sentences have grown, and it's not really the number of people in prison, it's the number of people in prison staying for so much longer. And I think there are really difficult questions for the review, and I will be very interested to listen to comments about whether you try and turn that curve largely by nudging judges or magistrates, whether the Sentencing Act 2020, of which I am no fan, it is far too complicated, whether there needs to be significant reform of that. I think it's really difficult. There are various, of course, cohorts of people in prison. One can identify the large remand population, which has been a problem forever, as far as I'm concerned, worse at the moment, but it's always been a problem. A newer problem is recall. I don't know any other country that recalls people to prison in the way that we do. And what's happened very recently is a huge surge in the fixed term recalls. So it used to be a problem of standard recalls, and people who recall, particularly people who are serving long sentences, being recalled and then serving years before the parole board re-released them. Now there's also, though, a huge increase in fixed term recalls, particularly for people serving much shorter sentences. There's the huge number of foreign national prisoners. I've never understood why our system is bad at sending home people who want to go home, let alone, of course, I understand the challenge of sending people who say this is home and or don't want to go anyhow. But even those who want to go home, we're not very good at doing it. In our analysis of the problem, we talked about the disproportionate number of people from ethnic minorities in prison, and there are many disproportionalities which we have to worry about. Why is it that so many black men prisoners get longer sentences? Because they don't plead guilty for very complicated reasons. The disproportionate numbers of mentally ill people in prison. There are so many urgent problems, I would say, if you look at the conditions in prison particularly. They are no place to keep people who are mentally ill. Of course, one of the major causes of this inflation has been tough on crime policies, penal populism, about which academics have written books. And I ask myself constantly, how do we stop MPs saying inappropriate things? There are constantly statements to the press talking up the punitive response. And again, Lord Phillips, fascinating. People didn't talk punishment only a few decades ago, and now it's all about tough on crime policies. There's Schedule 20, well, there's lots in the Criminal Justice Act 2003. Sadly, we've been told not to look at life sentences because, of course, life sentences are a huge, huge issue. Schedule 21, IPP. Maximum sentences have gone up, and I think we identify sex offences, knife crime, the death by driving offences are extraordinary changes, mandatory minimum. And I think it's a challenge to think what the review committee might say about that. The changes to licence periods, including post-sentence supervision, which I personally have always thought's nonsense to call it post-sentence supervision, tells me that it's illegitimate before it even starts. If it's post-sentence, it can't be true because it is part of the sentence, because you're being compelled to do something that you don't want to do. But I think there are interesting issues about whether we want to change licence periods, the weight of licence conditions. It's very burdensome. A huge issue is the lack of investment in alternatives to imprisonment. And there's so much that could be done in that way, promoting the greater use of open conditions, or the right sort of open conditions, rottles or post-release accommodation. The shortage of approved premises. Most of my own research work in recent years has been on recall and why people get recalled or why they don't get released by the parole board. The absence of approved premises and the very short times now that people can stay in them. Not that approved premises are necessarily good places to be, they can be really difficult places to live. Lots of problems in relation to community orders. I'm particularly vexed by the problem of the one community order with a long list of requirements which somehow don't quite seem to fit what the magistrate has to say with the reality of what's available. And I think there's lots of interesting things for us to consider around there, and why community orders have to large measure, particularly in the Crown Court, been replaced by suspended sentence orders. We talk in the report that's already published about media influences and the catastrophic impact of policy choices on delivery and quality of prison and probation services. Yes, we said that. And I think it's a really important and difficult issue about the relationship between prisons, probation, HMPPS, multi-agency failure to join up. They're really, really big issues which the review, of course, has to think about. I think that the review's terms of reference encourage us to be brave and adventurous. But I also recognise that I am a rather naive academic, and I'm the only naive academic on the review panel. Others are much more realist politicians than I am. And I think it is a really fascinating project to work out what anyone in this audience thinks that the review should recommend, and whether you would constitute individually naive academics or astute politicians or practical lawyers, and whether the recommendations that you personally might make would get accepted or whether they wouldn't. So from my point of view, it is a very, very interesting process. It also feels like a burdensome responsibility because, well, we mustn't get it wrong. I'm very nervous about the law of unintended consequences. You can make things worse when you thought you were going to make things better. And so I'm really grateful to be here today, and I'm going to shut up now because I would much rather listen than talk.
Thank you, Nicola. That was really very informative, very, very comprehensive, lots of food for thought. And I'm looking forward to our discussions around some of the topics that you have raised. Shall I move on to our next speaker? Is that Stella?
Yes, thank you. I just build on what Nicola has just said by saying that I'm welcome the review, and think this is a real important conversation to have about sentencing. Since I've been in practice, which is about 20 years, I have seen real learning brought to bear in the sentencing process, especially around guidelines to do with young people, to do with people who've been exploited and trafficked, and our understanding around modern slavery, to understand about trauma and the impact of mental disorder. So that learning has really been something that I've observed while I've been in practice. But it's also something that I have observed is the inflation that we've all been discussing. And this is an opportunity for us all to talk about really the option of prison. And if prison is the last option, and is only available where necessary, who ought to be in prison and who can be dealt with in a different way. And it seems to me one of the key issues really is resources, because there needs to be confidence and faith in alternatives to custody, particularly with respect to remand, but also in respect to perhaps an increase in the availability of suspended sentences, deferred sentences, which we don't see as much as we ought to in practice. We're giving people an opportunity to make changes, and that can often be very significant, because what all of the practitioners will be experiencing is we're often dealing with people who have had a case hanging over them for many, many years. Their case is now coming on for trial. They may be convicted, but of course in that interim period they may have grown up, they may have had significant events happen in their lives which have affected their profile in respect of risk of reoffending and the need to imprison them. And if deferred sentencing and a wider availability of suspended sentences beyond the 2-year minimum were available, this may give a bit of a valve for the prison population, but also actually achieve the aims of who really ought to be in prison, which perhaps needs to be the people who are a risk to the public. And on that topic, I just wanted to say a couple of things really about the topic of risk and risk assessments. Going back to the question of probation, we sometimes get probation reports to assist judges in respect of our clients, but with regards to more serious offending, often we don't get those reports as practitioners, and often the assessments of risk can be pretty basic and don't necessarily incorporate a more sophisticated analysis of the individual, the way that the assessments are set up. And what that really requires is a more approach to deal with that person, and more time and resources and training from the probation service. Lots of people that I represent are both very vulnerable, but also may pose risks. I represent a lot of women who may have committed serious offences, but actually, once you step back from their circumstances, are unlikely to be before the courts again. So there needs to be a much more tailored and individualistic approach to risk assessments, in my experience, and that will give confidence to judges, and perhaps give confidence to judges to make a decision on the guidelines, but also incorporating features of the person that they're actually dealing with. And that's particularly a case of, for example, with trauma. Well, lots of the people we represent have experienced trauma or have mental health difficulties. They may be trapped in a type of relationship or circumstance which have led to their offending, but with the right support will not pose a risk in the future, and may even be able to put that offending behind them. So risk assessments are a key issue that certainly I see, but again, it goes back to the question of the resources and the training, both of the probation service and also of the judiciary. What I've seen in my work is there have been, in my experience, and it may be anecdotally from others, a decrease in the sort of short sentences that we have all been concerned about, that seem to be ineffective, but were at one stage posed quite a lot. But where there are serious offending and there are longer sentences, those longer sentences are getting longer and longer. That's a multifactorial situation. We've got minimum sentences for some offences. We've got the 2/3 licence question. We've got extended sentencing, and we've got obviously life sentencing for murder with the tariffs. And what it seems to me sometimes that happens is if there's a pronouncement made, or if there's something said publicly about a type of offending, for example, knife crime, then it is said to be taken seriously. But in fact, something like knife crime is a very complex issue. Sometimes for our young people, an issue about welfare and safety in communities. And so it isn't simply solved by saying we need to punish people and that will deter them from carrying knives. All of us know that doesn't work. I have been dealing with a case today actually about firearms, and that's led me to think carefully about minimum sentences. The Court of Appeal have stated that in respect of firearms, that they're not able to find that circumstances of youth, good character, naivety, coercion are necessarily exceptional reasons to defer and change a minimum sentence. So there are many, many people, often women and often Black women and children, who are experiencing minimum sentences for drugs, for firearms offences, who are in many respects victims. And the Court of Appeal have expressly stated that if those factors are not exceptional, and of course being young and vulnerable and used in this way are not exceptional in these types of cases, then this would be subverting the will of Parliament. And this is an area that I think we should go back to Parliament about. Who do we want to imprison? young vulnerable girls or the people who carry guns and put those guns in those girls' homes. So that's one area that I think is probably really ripe for reform. Just one final feature that I perhaps would wish to comment upon. I understand the Law Commission are looking generally at homicide. We have murder tariffs that don't necessarily, in some ways, reflect the circumstances of offending, the way in which there sometimes are principals and secondary participants, the use of knives and weapons, which are elevate tariffs, but in fact, in practice, are in pretty much every case involving young people and women. If those are more nuanced and individualistic approach to sentencing, that doesn't deprive the public from and these cases from being dealt with properly, but it enables a judge who's dealt with a trial, for example, to properly assess all the features of the culpability, but also of mitigation. So it seems to me this is an area, and I appreciate it's a very complex area, but this is a beginning of a wider conversation about sentencing and resources, but also our priorities as a society. And I'm hopeful that in due course, if there is reform of the homicide legislation, that will also include a proper look and another look at tariffs. So thank you very much.
Thank you, Stella. Before I move on to Andrea, I just want you to make note of one of the questions that we have that touches on exploitation and trauma and how that impacts young persons in the criminal justice system, particularly children. This person is referring to a 16-year-old. I know the review is not looking at children, but as we're having the discussion about trauma and the impact of trauma on particularly, people, vulnerable people in our criminal justice system, I want to throw that one out to you. And for all of us to think about joint enterprise, not specifically identified as an issue as a part of the review, but a big issue, a big topic, and it's in the chat raised. So I want us to pick up those among others when we open out to the discussions. Andrea, thank you, and over to you.
Thank you very much for doing this event with us. We're really thrilled to partner with Garden Court Chambers to talk more about sentencing. I've decided to, obviously the Howard League is one of our priorities as an organisation is sentencing. Nikki's already mentioned the report that we did last year with Nicholas and with Lord Phillips and 3 other retired Lords Chief Justice and Brian Levison. It's a huge priority for us, and there are very good reasons for that, which we're talking about today. But we are a membership organisation which includes hundreds of members in prison, and I thought I'd today think about them and sort of try to focus on why all of this matters. So if we could go to the first slide. This is Wandsworth Jail from 2022. I think it's fair to say that that photograph probably does it more justice than it deserves. If that was today, that would be a double bunked cell, so there'd be 2 people in that cell. But the truth is sentences have got longer and longer. We know that. We've talked about the reasons why that is the case today. And the prison system is on its knees. And so you have cells like those in Wandsworth that are miserable places that have suffered from years of underinvestment. The prison system as a whole is overcrowded. Since 2023, 8 prisons in England and Wales, or in England, have been subject to urgent notification from the Chief Inspector of Prisons, which is essentially kind of urgent measures, special measures for prisons. And indeed, there were 3 in the last 3 months of last year: Manchester, Rochester, Winchester. And in one of those jails, one of the people in the prison was able to take his own cell door off using cutlery. I mean, these are places that are really sort of falling apart. And there's a huge pressure on the system for more prison places. It's running hot. So earlier this week, the system was 98.9% full. That is not a lot of spare cells. I was at Pentonville Jail on Monday. They had 8 beds free that night. There are a similar number in another London jail I visited in the week. So on Monday of this week, we had 87,199 people in prison. 83,300 of them are men, nearly 3,500 of them are women, and 339 children in young offenders institutions, which is 105 more than last week, but obviously 1,000 fewer than this time last year because of the early release scheme, SDS 40, which has seen people released earlier. But by the prison service's own measure, we have only safe and decent accommodation for 79,000 people. So we're 7,500 over that. I have to say what the prison service think is safe and decent and what we at the Howard League think is safe and decent are considerably different. This is a system where we have more than 22,000 people sharing a cell originally intended for a single person. And there are, I think, 18 cells where 3 people are in a cell intended for a single person. So prisons are overcrowded. Probation is also overcrowded. I can't bring you photographs of crowded probation, but in the same way that the prisons are under pressure, probation is similarly under pressure, and it is a service that has been traumatized over the last sort of 10 years of government. Next slide, please. I'm just going to go through a few of these just to remind you of what we're talking about. Oh, that's I've got 2 slides that have rats on them. One's a dead rat at Wandsworth, and this is a live rat at Manchester with an orange. But in lots of our Victorian jails, particularly, vermin run rife. Last summer, the kitchen at Pentonville had to be closed because of a rat infestation, which is extraordinary. People were slipping in rat urine. Next slide, please. The Brinsford toilet. I also have a couple of toilets from Brinsford in my slide pack normally. This is the cleaner of the 2. Next slide. This is Eastwood Park from 2023, where inspectors went in. So this is a women's prison in Gloucestershire. At the time I went there, around the same time as the inspectors, women were locked in their cells across most of the prison. So all but one of the wings, women were locked up for 23 hours of a day. I mean, Stella's described kind of vulnerabilities of women. A lot of these women were on remand and held in terrible conditions. If the next slide has a quote from Charlie Taylor saying the cells were appalling, dilapidated, covered in graffiti. One was blood splattered and had some extensive scratches on the walls. That's actually the one you've just seen the photograph of, which reflected the degree of trauma of previous residents must have experienced, and then said no person should be held in such of these conditions, let alone women who are acutely in distress. And as one of the comments that has just popped up has said, this is all the same, all of this is true in the children's estate as well, that the estate is not old in the same way that it is in the adult estate. But the conditions are poor, use of force is high, segregation is widely used, and there is very little regime across most of the children's estate, which is something that our legal team is looking into. So these are prisons that are not safe and they're not decent. It's the result of years and years of increasing a prison population with insufficient planning. I mean, it's not like this has come out of nowhere. It has been forecast for years that we would find ourselves with a prison system that is just over full, and where there is a lack of resource. So because obviously when you have 87,000 people in prison, you need a lot of money to be able to hold them. We don't have a lot of money. That's very clear from everything the government says. And so it's spread very, very thin, and which is why we have sort of a lack of regime across the piece. And as one of the comments has just said, most people across this system are locked up 20 hours a day and more on weekends rather, including children. There is an expectation undoubtedly from the public that people in prison are rehabilitated. Everyone in our prison system is coming out. All but 65 of them will be returning to the community. That's the intention. and yet this is the way we are holding people. Next slide, please. And so we last summer did a report with some of these people, not all of them are photographed there, which managed to talk about this issue of sentence inflation. And I think it's interesting that Nikki's going to get her students to do a comparison, because she has been involved in both of these reports, having helped us with it as well. But I thought my favourite headline was actually from Lord Phillips in Inside Times. The headline they ran was, "It's a con trick." He basically said that longer sentences have been a con, sort of on the British public, about the English public, about what prisons can and can't achieve. And that's definitely very much our sort of thinking. I spend a lot of time in prisons, hearing from our members in prison, with a focus probably more on the longer term estate and remanded prisons and recalled prisoners. So I thought I'd share with you a few of the things they've told us about sentencing. Next slide, please. The first one is actually somebody who came up to me on a wing in One Life at Prison. He was at the time 28 years old. He had been serving 10 years in prison at that stage. And he said to me, "Miss, what am I meant to do? I've done all the courses. I've been to Grendon. They've broken me down and they built me up again. I've been fixed. What am I meant to do in prison for the next 18 years? Which is a question I'm incapable of answering to a 28-year-old man who's full of regret for what he's done, and is now in a prison, in his case, where he's out of his cell all the time, but with literally nothing to do for 18 years. And I think worth remembering that open prison at the moment is only available to you, I mean, most people 2 years from their release date, theoretically 3 years from release date. So he is looking at a very long time in the closed estate. That is something that our members are concerned about, and hopefully will be in Nikki's, or in the Sentencing Review's report. We know from David Gawke's media over Christmas that that's something of interest to him. The next slide, please. There's also obviously, with longer sentence people, a real pressure to behave well for a long period of time. So this is a quote from one of our members who's currently halfway through a 35-year sentence. He successfully completed his sentence plan in the first 3 years he was in prison. So then he's got 32 years to then just wait, and talks about the high level of discipline required to get through a sentence like that and to keep on being supported through progression. A lot of our responses from our members highlight rigidity in progression structures, hampering rehabilitation, and they strongly support the idea, which was raised in the Sentencing Review consultation, around incentivising behaviour. The next slide, please. Again, one of the quotes was, "Good work in prison doesn't get you home any quicker. Demonstrating consistently good work should reduce sentences for those who really want it." And that is, I think at the moment we have the stick. So if people behave badly, they can get extra days added, but we don't have any carrot for good behaviour. Although I have to say, doing a lot of media and phone-in, radio interviews, often people think that we do, that they think you get time off your sentence, like you do on Law and Order or American television shows for good behaviour, whereas that's obviously not true, with the exception of children HMPs who can show exceptional progress unanticipated by the original sentencing judge. So this idea of incentivised work leading to reduction in time, I think, is certainly something that our members really welcome. One of the real strongest themes of our feedback from members was about recall stemming obviously often from foreseeable problems, such as lack of housing or communication with probation, which ought to be really properly sorted out before release. We have a long list from our members of the many instances where people have been recalled for administrative breach, which is obviously most of them. And as Nikki said, being recalled to prison for administrative breach is a very new thing. It used to be like 25 years ago, there were 100 people in the recall population. Now we have, thousands and thousands, 13,000 or something. So we've had people recalled because they were attended at the wrong address, or they failed to recognise exclusion zones, or one went through a bus through an exclusion zone, or somebody was recalled to prison because he missed a 1:30 probation appointment on the day that he was released. He wasn't actually released until 5:30 that day. So he missed his 1:30 probation appointment and was therefore recalled to prison. And the vast majority of them, as somebody just put in the chat, see no further action in any event and then take a long time to get re-released. Next slide, please. What our members often express concern about that prisons are really unsuitable places for older people and older adults. I was recently, a few weeks ago, in a prison where there are 2 wings of 120 people each on each wing, of all of men over 65, many in their 70s and 80s. The governor said there were 240 men on these wings. The governor was saying that he attends 20 to 30 funerals a year of people just dying of old age. I've been in other prisons where there are palliative care units, extremely expensive and pretty awful way to be dying. And in fact, I was speaking to a governor earlier this week who is supporting one of her prisoners in the community who's not been given compassionate release, but through Russell trying to get support for that person to die with a bit of dignity in the community, because prison is a very difficult place for that. So we obviously need to do things differently. Sentencing practices are key to that. They impact on this system. That's why we've got this system that's on its knees. But they also desperately impact on individuals. I mean, I see these people when they are, you know, halfway through their 30-something year sentence, and you just think, what is the point of this? And I keep going back to the same prisons and seeing the same people, and they're still there. They're just always there. And then sometimes there are new people because they've been recalled. It is not a way to run a legal system. This is why the sentencing review is really so important. And as I've said to Nikki a number of times now, every time I meet with ministers, I am told about the sentencing review. The sentencing review is the answer that the government seems to be leaning on very heavily for the current pressures. I'm optimistic because they can't build prisons quick enough. So they're soon going to run out of prisons. So they're going to have to do something to reduce demand. Now that is right as a matter of morality, in my view, and as a matter of law. It is, I think, probably what will lead to sentencing reduction is pragmatism around actually having the space to hold people. But there really needs to be a fundamental reset about the way sentencing practice operates. There needs to be, as Stella said, real courage from government to tell the public, you know, what prison can and can't achieve. It's very lazy, I think, to tell the public that they're safe because people are going to prison. You know, that's people are safe for the period of time that person is in detention, perhaps. But it's much more complicated to talk to the public around what really does drive crime. And we all know, I'm sure everybody on this webinar, you know, knows that it's a lot more complicated to stop, to support desistance than just to throw people in prison. There needs to be a serious engagement, I think, and honesty from politicians about what prison can and can't achieve, because at the moment our system is failing people in prison, but it's failing our community more broadly. Thank you.
Thank you, Andrea. We've had a lot of discussions in the chat. Lots being thrown in for thoughts, you know, conversations around the disproportionate representation of Black people in the criminal justice system and in prisons. You know, racialized attitude towards individuals in the criminal justice system. Nicola touched on that as in her presentation, but that's something I'm hoping that we will pick up as well as a takeaway. You know, the elephant in the room is around resourcing. You know, we all see the lack of resourcing around probation and keeping people inside for years and years on end. You know, like the person you speak about, Andrea, who says, yeah, so, you know, what do I do for the next 18 years? Or I finished my plan in 3 years. Now it's 32, 33 years to go, right? We institutionalize young people, and then what happens to our human resources? Joe, I'm coming over to you and then we will open up our discussion. So please look at the Q&A.
Thank you, Thalia. I was just going to pick up, first of all, actually, on something that Andrea was touched upon, and that's really the children's secure estate, because they really have been hit very hard by Operation Safeguard and the various policies that have been put in place. It's storing up a lot of problems, in short, for the future. So at the present time in the children's secure estate, those who pass the age threshold of 18 are remaining in that estate. And there simply aren't, as are the pressures across the more broader prison estate. You know, resources are limited. There are huge significant pressures, but it has a real impact actually on what we are supposed to be seeing as rehabilitation, because this equally applies to those prisons that typically house or hold young adult prisoners. You have significant movement orders in place, which are effectively orders that prevent individual children being moved from location to location, if and where they may come into conflict with another young child who's held within that particular secure institution. And so if you are keeping and retaining those children who are 18 past the age of 18, all you are doing is adding an additional layer of a greater number of those children and all of those very complex interactions that, in fairness to prison officers and governors, they have to manage every single day to keep those children safe. What does that mean in reality? Well, it just means that those children are not in education. It means that they're not getting outside. It means that they don't have access to all of the things that actually you'd expect to see in a civilized society. And in particular, as I say, when looking at what the purpose for certainly children is supposed to be, the prevention of reoffending and rehabilitation. And so as I say, you're storing up those difficulties, looking to the future, what will happen when they come out? Are they going to reoffend, recidivism rates, all of those things, but also putting all those children at quite significant risk, along with actually those prison officers who are working within those institutions. So it has lots of knock-on impacts that aren't necessarily immediately obvious from the outside, but ultimately affect those children's lives quite severely. I also welcome the review. I hope very much that it is going to be a proper opportunity to have a really serious grown-up conversation about sentencing, which is something that we've been sorely lacking for quite some time now. It does, as somebody's pointed out in the chat, require quite bold decision makers. But part of that, I think, Andrea, is what you've alluded to already, which is having that grown-up conversation with the public, explaining what works, explaining what doesn't work, dealing with a lot of the myths that you see floating around. And I've seen one of them, one aspect referred to, and I don't know exactly what offences it relates to, but it talks about longer sentences for less serious offences and shorter sentences for more serious offences. As I say, it's not clear exactly what that refers to, but one of the things that we do see a lot of relates to the sentencing of individuals and indecent images of children. That's something that has been a real flashpoint recently. And it is right to say that certainly in my experience and in my practice, large numbers of those individuals committing those offences, I should say, for the first time, often of good character, often coming before the courts, and certainly since COVID, come from a whole cohort of people, from the very young to actually individuals in their 70s and 80s. It's really quite pronounced, and I'm sure I've not looked at the stats, but I'm sure there was an exponential rise during COVID, not least because people went online, and unfortunately, and I say this from experience of representing many of these people, an awful lot of those individuals who effectively have gone down a rabbit hole is probably the best way of describing it. That's not to minimize what they're doing at all, but I think most people would be quite surprised to see the background and then how they've ended up there. But the reality is that a large proportion of those individuals do receive some type of non-custodial sentence. And the answer or the reason for that is because typically within that non-custodial sentence, they can access some form of offending behaviour work. Whereas if they were sent to prison, that work is simply not available. So in the long-term protection of the public, what you're trying to achieve in relation to imposing a non-custodial sentence is that both the punishment aspect in relation to other aspects of the sentence, but also that rehabilitative focus to stop it, in short. But again, that's not something that is discussed. It's just seen as these are incredibly serious offences, which they obviously are, with huge significant harm being caused to those children. But it is a much wider, more complicated picture than simply saying these are really serious offences and people are receiving very short sentences or not going to prison for them. And that's a sort of grown-up conversation that I think has to take place with the public, so they have an understanding of what these sentences mean. I do think it's going back to the review itself. As I say, I really do hope that and that it can be brought upon that this opportunity is really properly gathered. I do, however, think that there are missed opportunities. It doesn't include children and the youth estate. It doesn't look directly at life sentences, which are one of the biggest drivers of sentence inflation, and again, storing up significant problems for the future, not least through the most recent 2022 changes, which I'll come on to in a moment. And then thirdly is looking at the role of disproportionality and race, because that is a significant issue, and again, it's not included within the review directly, and one has to question that, because ultimately, when one looks at the makeup of those individuals and that level of disproportionality, unless you're addressing that issue, then where are we really going with it? So I just wanted to touch on a couple of things there, really. In terms of life sentences, they're a really quite notable cohort within the prison estate. I think, and it's quite helpful, the review sets it out itself. You know, there's almost 8,500 people serving indeterminate sentences, 7,500 approximately of those are on life sentences. Average minimum term had risen from 13 years in 2000 to 21 years in 2021. I've no doubt that in the last couple of years, the length of those average sentences must have increased because of the recent changes in Schedule 21. Schedule 21 and the changes in 2022 were largely brought in actually under the radar. Very few people, ironically, were aware of them until they came into force. But they changed sentences significantly, and particularly for children. So whereas before you had a single 12-year starting point for children that would go up or down depending upon the nature of the offence, and could go up quite considerably, I have to add. Now what you have instead are a range of starting points, 9 in total, which vary depending upon age, whether you're 14 or under, 15 or 16 or 17 at the time of the offence. And then they are read directly in conjunction with what an adult offender would receive. So for a 17-year-old, if the adult offender, for example, would get 30 years on the Schedule 21 starting point, that 17-year-old is now got a starting point of 27 years. That is hugely, hugely greater than what it used to be. We are seeing these in our practice because there's very little discretion. These are being handed down. And it goes back to what you were saying, Andrea, about what do you do once these children or young adults have actually hit all the targets they can hit, and what do they then do in prison for that remainder of that period of time? And you referred to the fact that for some of those, well, certainly for children, there was at least the review mechanism, albeit it only ever really resulted in about a year reduction or so. But even that was taken away to a large extent from those children. And one has to query then, what do you do in relation to rehabilitation? Where is the rehabilitation in that respect once you've gone past that point? These are children who are going to be in prison for very serious offences, not to detract at all from the gravity of their offending. People have lost their lives and the trauma that comes from that, and there must be punishment. But one has to question whether or not we're now in a straitjacket situation where it's just that aspect that's too long, there's no discretion available anymore. The recidivism rates are quite interesting in relation to life sentences. I'm sure partly because they were for lengthier periods, and so ultimately the evidence base is that children and young adults grow out of crime. But it's 4% compared to 42% of the overall prison population. So those reforms were really quite a knee-jerk reaction to a high-profile case at the time. And then in 2022, as I say, we saw those changes. And that's typical of what we've seen for the last decades or more, it's a reaction. It's not a thoughtful reaction. It's not one which takes any real consideration. It's just one to try to appeal to the public. And so looking more broadly then at what can we learn from the approach to children? Well, there's a strong evidence base that children and young adults typically mature out of it, and that actually any criminal justice system intervention doesn't really assist in that regard. But in fact, it's relationships, it's employment, it's assisting with housing, it's all of those aspects which are far more complicated and resource intensive to put in place that we just simply don't have anymore. And there's a really interesting study up in Edinburgh that demonstrates that actually those children who matured out of crime, typically those that had no contact with the criminal justice system, did the best. And so that was a cohort followed over 30 years or so, and those that admitted criminal offending but actually hadn't had any intervention, hadn't been caught, nonetheless, ironically, were the most likely to desist from offending. So we're not doing something right here, we're doing something very wrong. And I can't say it's a great surprise, because if you put a group of children who are the most and young adults who are often the most vulnerable individuals from our society with huge amounts of trauma in their background, if you, as somebody who represents these lots of individuals in this situation, you see a typical pipeline from school exclusion, different adverse child experiences all the way through. And you put them all into somewhere which is under-resourced with no real rehabilitation. You have to question, well, what is going to be the outcome? And the outcome is often going to be one that's very dysfunctional. And that's exactly what the research demonstrates. So what can we learn then from the youth justice approach? Well, certainly the numbers of children that are coming into contact and staying within the criminal justice system have decreased quite significantly, which can only be a positive. Diversion is actually starting to be used a lot more and well. And in that respect, it would be good to see more use of what's called Outcome 22 from the police and looking at deferred prosecutions. So these cases don't need necessarily to come to court. It's a police outcome code. It's when the police decide to defer prosecution until that individual has been given an opportunity to engage with intervention activity. Those sorts of steps that could be taken. Again, then looking at what happens with children, referral panels, you have a community panel that's overseeing it. Something similar could be instituted for those types of offences. Women, it seems to me, are often, frankly, one of the key constituents that probably would benefit from that. And also in relation to deferred prosecutions, frankly, for many, many offences, they may as well be anyway, because they're not going to come into court for 3 years or 4 years or more for an awful lot of that offending, the offences that we see in court. And then obviously there's a further review. Then if I can just touch very briefly on other aspects, we've seen problem-solving courts that have been used to great success in the family courts in terms of drug and alcohol courts. Having greater oversight, whether it's judicial or community-based oversight, often works as a real incentive. It's again going back, Andrea, to what you were talking about earlier. It's having not only a stick, but also a carrot. I think what's really sad, actually, when you do our job is seeing, and it's a positive of the system when it works, is seeing the relationship that builds up between an individual and a judge that has sentenced them. And it's often in relation to drugs rehabilitation. And they come back every month or every couple of months to give an update. And that relationship is actually a really important one to that individual. It's often the first time anybody's really given them a chance. And they really do develop, as I say, it's quite touching. It's also very sad because actually that shouldn't be the first sort of relationship where something positive is happening. But it's a very positive approach. But because of the resource constraints, we've just seen that effectively die away. And so you don't get those sorts of that sort of oversight anymore. You don't get those check-ins. You don't get, okay, I've just got to get to, 1 more month. Let's see how I get on. I might have relapsed, but actually I'm doing it again now. Those sorts of discussions. And all of that has effectively just slipped away. And certainly in my years of practice, when I began, it was fairly common to have reviews. Those just simply don't really take place now. And I think that's a real shame, actually, because I think they had a real part to play. And I think that if we can learn from the family courts and drug and alcohol courts that they instituted, then that would be a positive thing. Similarly, it's a lot of reinventing the wheel, isn't it? Because there were domestic violence courts at one point that were equally quite effective and dealt with things in a different way. And I think there has to be a recognition that human relationships are complex. They're not always straightforward. there are often situations where those individuals, regardless of what anyone else's view may be, will continue to engage in a relationship, and that relationship will continue to be a very difficult one. And what assistance can be given in a problem-solving court in that way? Not least because of the potential for real spiralling out of all control and things, and the very worst consequences that certainly Stella and I often see in our work. Touching on race for a moment, as I say, I do think it's a real missed opportunity, because if one just looks at children, for example, as I said, there's been a massive decline in the numbers of children that are in custody. But set against that, the proportion of ethnic minorities within children rose considerably, and they've been rising now for decades. So they rose quite considerably from 2006 to 2016, from 26 to 42%, and now at the end of March last year, it was up to 51%. There is something seriously wrong with that picture, but again, it's something that's not being grappled with, and it needs to be grappled with. We need to ask ourselves why, and that ethnic disproportionality it carries on throughout the entire system. So it's not just children, it's young male defendants, it's practically, as I understand it, at every single age. And so what you see is significant overrepresentation. You see higher average custodial sentences, longer sentences, higher odds of receiving prison sentences. And again, despite efforts to really try and grapple with that, with David Lammy's review, nobody's really got to the bottom of it or actually found a solution. I think I can give one example. So a positive step is that in the sentencing guidelines, which judges must apply, judges have to consider race and racial disparity and disproportionality. But equally, the practical question that arises from that is, what does that mean? What does it mean in practice? It doesn't mean that you reduce that sentence. So what does it mean? Is it just a check? Are you supposed to sit as a judge, step back and just ask yourself, am I applying this sentence unfairly? Is there some element of racial disparity? Am I approaching this in a racist manner? Ultimately, that's just not going to happen. It's unrealistic. And so what does it actually mean? What can you do with it? One significant issue, and it's been touched on already in relation to that aspect, is credit for guilty pleas. And that was, there were significant reforms, actually, ironically, as part of the Leveson earlier reviews, and obviously we've got another one at the moment. And that was all about incentivizing early guilty pleas. And one can see the advantage for that from our resources for the court and so on, and other more perhaps profound public policy reasons. But set against that, the reality is that there is a relationship with ethnic disproportionality within the criminal justice system. We know that people from ethnic minorities are typically, according to the Lamy report, and there's no reason to consider that's not correct, are less likely to plead guilty. What does that mean in practice? They're going to get a longer sentence if and when they do eventually plead guilty, or if they're convicted after a trial. And the real problem there is that the sentencing guidelines, again, for credit for guilty plea, really remove that element of discretion. So the maximum credit is plead guilty in the magistrate's court. Nobody on a serious offence is going to plead guilty in the magistrate's court, not least because if you are looking at serious offences, for example, different types of conspiracies, often the material is just not there, whether it's in the summaries are often inaccurate, roles are not defined, the exact criminality that individual has been involved in is not set out properly. Were they to plead to that, they'd be pleading to something ultimately that they weren't, where the boundaries are just not clear. And so there's a real disincentive to plead to those in those circumstances. Aligned to that is the fact that often individuals will have seen a solicitor or counsel for a very brief period of time, often never met them before, often because it's a duty solicitor, have very limited papers in any event for the legal advice to be given in relation to. And so immediately you've left the magistrate's court, you're now in the Crown Court, you've already lost the opportunity of a reduction in sentence. And there's very little, save for quite defined circumstances, that any judge can do about that. And those disincentives then continue because you're down to 25%. You go past the hearing at which you enter your plea. Typically, again, the evidence has not been served at that point because we used to have committal proceedings where the evidence had to be served. And so by the time you got to the Crown Court, you had the foundation of the evidence against you. That no longer exists. So you can be at a plea hearing where you've got a summary of the case against you. Go past that point where you're down then onto a sliding scale, down to 10% on the day of trial. Get to the day of trial. If you're looking at a potential 20-year sentence, then actually 10% doesn't really make a lot of difference at that point. You may as well just roll the dice and see what happens. And so these are all the issues that are currently all combining to ultimately increase, if an individual is convicted, obviously the length of sentence that they've got, so that you're unable to have those proper conversations. You can try, but credit doesn't really take you terribly far when you're on the day of trial. And the judge has very limited discretion to do anything about that. There's no pragmatism within that system. I appreciate that what it does do is it provides clear guidance and guidelines, but by removing that discretion, what you effectively are also doing is removing those incentives, even at that late stage, to plead. And that again feeds in yet again into all of these issues of disparity. It feeds into the length of sentence. It's just not a very enlightened way of thinking about things. There just needs to be a bit more flexibility within that system. And ultimately, the court benefits if there is a guilty plea. The individual benefits if there is a guilty plea, if they are obviously guilty. If not, then they clearly should be having a trial and dealing with it that way. But where those individuals or effectively enter late guilty pleas, those are the sorts of things that we need to properly be looking at. And I'm afraid I think that a lot of the reforms that have taken place have not actually been as pragmatic as perhaps they could have been, because it's just not how it plays out on the ground. It's great in principle to say, let's incentivize an early guilty plea, get that, see what we can do in terms of getting people through the system early, get them into the magistrate's court. If they're guilty, they can plead guilty, they can receive a discount off of their sentence. But it just doesn't work like that in practice. So I think there are all of those different issues floating around. And so, Nikki, I don't envy you, frankly, in your job, but there's quite a lot to work with, I think, potentially, which is the good thing about it. And if there really is that true commitment, and there's no reason to believe that it's not a true commitment, because otherwise why set this up, then actually, hopefully we will see some benefit and some good come out of this. Because I agree with Stella, ultimately, when it comes to prisons, the individuals, there are always going to be a cohort of individuals who are dangerous and present a high risk to other individuals. And there's a real issue as to how that is dealt with. But an awful lot of the people that are currently in prison do not fall into that category. A lot of them, were there to be better resources and different diversionary approaches taken, and probation to be resourced properly. It was once better resource, certainly over the course of my career, where housing could be assisted with, having some level of stability, having some level of training to actually go into a job, to do all of those things, and relationships, proper relationships were being built. You saw real progress. And you just don't have that now, unfortunately. But it does require also money. And so that's going to be a real test of that commitment. But ultimately, one would think it would probably be cheaper in the long run. So looking at efficiency and all of those sorts of things. And certainly just picking up on one of the comments within the chat section, that there are indeed too many people with mental illnesses within prisons, and also just more broadly within the criminal justice system. There are real difficulties because, as we know, it's not the police often get called out to mental health crises. That starts a ball rolling in a very different way. Those individuals need help rather than simply, as I say, being arrested by the police, detained, often for potentially good reasons initially, but unfortunately snowballing in a very different way. And it would be helpful to have mental health practitioners in different places, and signposting and resources. But I think I've got a very long wish list, and it's not Christmas. So I'm equally trying to be relatively pragmatic. So I hope that helps, Valia.
Thanks so much, Jo. You have taken us almost to the end of our allotted time, but you have comprehensively covered a lot of topics that have been raised in our chat. One of the recurring themes, though, is joint enterprise, overcharging young people and where do we go from here in terms of dealing with the issue of joint enterprise, it not being specifically dealt with in the sentencing review. I'm going to throw those themes out to the panel. And in our roundup section where I will leave it to the panel to come in on points, I would certainly also like Lord Phillips to come in at some point, having taken us from a trajectory of where we started when you were looking at rehabilitation, so shorter sentences now to people spending their whole lives inside. Any thoughts on where we go from here, from your perspective, as a part of the roundup? I see Andrea with her hand up. Do you
I
want
was
to
just
come
going to say that joint enterprise does not form part of the sentencing review.
Yeah.
But the government has indicated that it was always going to deal with murder frameworks in a separate review that it's put onto the Law Commission, which does explicitly mention joint enterprise. So I mean, it's a little bit, I worry a little bit that's kicked into the long grass, but it does have a place, and there will be an opportunity. And we know, because of the current review that the Law Commission is doing on criminal appeals, that they are very concerned about the way joint enterprise criminal appeals are being handled by the courts of appeal. That, I mean, I think a number of people in the school had conversations with them. So there is reason for hope, just not with this review. I guess that there are things that will come of this review that will help people, particularly those who have been sentenced a while ago, which would be things like potentially accelerated moves to open conditions, like an expansion of the open estate, which will mean that people who've got a very long time in prison will hopefully be able to get out earlier in their sentence. Will get into open conditions, and therefore be able to start, going on home visits for 5 days at a time, and having all of that engagement with family, which I accept is not release and brings its own pressures. But there is still something in this for people who have got those murder sentences. That's all I want to say. Thank you.
Okay, you asked me to say a few words. I found this discussion intensely depressing. The problem is dealing with a small minority of the population who behave in an antisocial way for very many different reasons. And to punish them for doing so isn't the right answer. It really is not. You've got to have a degree of punishment in society, but we've gone completely overboard with this. We ought to be, first of all, looking for the most cost-effective way of benefiting society as a whole by dealing with these antisocial people in the best possible way, i.e. a way that will help them, will help society by making sure they don't reoffend. And we're miles away from that, and I can't see how we're ever going to get back. I was impressed with my historical survey because I found it such a surprise. And there were bad things that happened 60 years ago. But when I look back on it, I think we were living in halcyon days there compared to where we are now.
Thank you for bringing us back to center. One of the things I really want to throw out, we've talked about resourcing, and I'm conscious of the time and people may drop out, is recommendations becoming bookends. We've talked about the Lamy review, and quite frankly, it's become a bookend, a reference point for many of us to quote, but there isn't the substantive will to deal with the issue of race and the disproportionality that's associated with it. And, let's be frank, it is racism and the way that people of color are treated in the criminal justice system. So using the Lamy review as a reference point of something that has quite frankly become a doorstopper, how can we ensure that the recommendations of this review are meaningfully implemented and have teeth? I don't know. That may be quite theoretical in being posited, but it's something that we really have to deal with, because then we will have celebration on the findings, pretty much telling us what we knew, but then cloudiness and depression if the implementation is not effective.
I just say one positive thing, or at least on that topic, which I entirely agree with you, Thalia, that it's very depressing. The gang matrix is no more, and the gang matrix was something that we used to see a lot in probation reports about our young people, talking about somebody is reluctant to go somewhere else in London by themselves, and therefore they must be in a gang. Got to get away from that. We've got to challenge that, but we are making some progress as in respect of those kind of stereotypes and helpful orders that we're seeing in court. And I'm certainly seeing some proper inquiry from the judiciary about that kind of work. So those of us who've been pressing to try and ensure that courts take a more individual approach and don't fall into stereotypes, there is some movement, glacial movement, but there is some movement, and a lot of this requires some better training, frankly. We have the Equal Treatment Bench Book, which is a really useful tool. What that tells us is that many people, particularly women and Black women especially, do not think that their accounts will be believed, that their experiences are not properly recognised in court, and certainly that's my experience. I'm sure that's the experience of other practitioners, but that is set out in terms in the bench book, and training is just so important with respect to the judiciary, that they are noticing these things, that they aren't just paying lip service, but they actually are aware of the learning and these disparities and bear them in mind.
Thank you for that, Stella.
Just on the Lammy review thing, I mean, obviously David Lammy did the review for David Cameron so effectively for the last lot of various iterations of their government. I have a lot of meetings with ministers and have had meetings with the Sentencing Youth Justice Minister, Sir Nick Dakin, where he has raised the Lammy review, like without prompting from us. I mean, I think it is something that they're trying to work out what they need to do, but they have a stated, I think, commitment to implementing the Lammy review. We're yet just to see what that means. So I'm hopeful that it will become less of a bookend, because I completely agree at the moment that it's something to which lip service is paid. But, you know, David Lammy has now got one of the great officers of state and is at the heart of the government. And he knows, for example, the injustices that joint enterprise wraps upon Black communities. So I guess I'm a little more hopeful about that. Certainly a lot more hopeful than I was sort of before last July.
I mean, can I just mention in terms of the joint enterprise, which I think a lot of people in our chat have raised rightly, because it's something that operates in many cases very unfairly in respect of children and young people, and also those children and young people who have other issues like trauma or neurodiversity, is that the role is always something that is considered by in the sentencing guidelines. So there is the distinction between the leading role, the principal, and the secondary party. But that said, the judge still has to look at the tariff. So they're still looking at the global tariff. Someone took a knife to the scene, for example, but they're not actually looking at the role of the individuals, or not sufficiently within the way that they can sentence. So this is really part of the reform of homicide, and looking at availability of different defences, bringing into that sphere our learning about trauma and different responses and immaturity, and trying to reflect that in sentencing so we can get somewhere in respect of mitigation, but we can never really dislodge those tariffs. So it's something that's really, really very critical. I think there's some comments in the chat about how this review will impact people who are already on these sentences as they're coming up to parole boards. Will there be any opportunity for this learning or the way in which sentencing has developed to impact parole, or the 2/3, for example, sentencing? Do we know if that might be something that's considered?
I'm sure that it'll be considered, but I can't say anything about what will come. I mean, I can't say because I don't know what will come out in the review, so I can't comment.
Yeah, I mean, I think part of the difficulty with that at the moment is that obviously life sentences, which are one of the major issues here, is not part of that review. I appreciate, as Andrea's pointed out, it's going to be separately considered. But I think there are significant barriers actually to the government in terms of presentation of those issues, which I find, I'll be frank, inherently depressing. But I think it's probably one of the hardest things to do actually is look at those sorts of sentences retrospectively. So I say that just because that's not an area that I have a great deal of hope in relation to. I very much would like to be proven wrong, but I also don't think it would be right to raise people's expectations in that respect, because I think that's probably one of the sort of ones that's very, very far removed from being a likely outcome of the subsequent reviews. I suspect it's more looking to the future than it is necessarily in relation to life sentences that are currently being served. As I say, that's not part, as I understand it anyway, of the review that you're involved in, Nikki, but it's something that certainly if it's a law commission issue and those sorts of things, it's far more likely to be prospective rather than retrospective. I'm sorry to end that on a very depressing.
No.
What I would like to see, what I would really like to see for those sorts of sentences are, and I think it would be something that could be seen to be acceptable, which is always one of the flip sides of the coin, is what is something that could be seen to be politically acceptable, is looking at some sort of review mechanism within those sentences, because I think that is a way where individuals who have made typically great progress within the custodial estate and have done, as you say, as you pointed out earlier, Andrea, everything that they can do to actually have that sentence reviewed properly, because that is a real lost opportunity actually, and that could properly address, to some extent at least, those sorts of issues. And that I think is something that could happen. But I think that looking at, as we've just seen in terms of the 40% to serving of sentences instead of half, I don't think we're going to see anything like that in relation to life sentences or those longer sentences at the moment.
Can I just come in on something, right? And I think that discussions have to be real. And people, when we are charged with reviewing and making decisions and assessing, we really need to be real and look at things in a holistic way. Andrea was very graphic, and I thought really great in presenting the slide pictures, because we're looking at people living and spending, decades sometimes in their lives in inhumane and uninhabitable conditions, rat-infested, nasty environments. When you put people in those environments with no hope, and I think, Joe, your suggestion of periodic reviews is something that we should actually quite look at, because I find sometimes that discussions take place in a vacuum. And until politicians really come and grapple in real terms with the conditions that people are being placed in, it's not humane. Then we run the risk of decisions being taken on the left hand around policy and the reality on the right hand being different. So I think that the approach needs to be much more holistic and comprehensive, and look at people who are being sentenced, 19-year-olds who are being sentenced to 25 years because they made a wrong decision at some point in time in their life as young people. being placed for the rest of their lives in in institutions that are not fit for human habitation.
Just to say, I did put into the chat then the sentence inflation report that Nicholas led for us. And we weren't limited in that report to exclude murder, and we did suggest that there should be a review mechanism for those sentences.
Thank you very much to our panel members. I just take this opportunity to thank our participants. Most importantly, I see the numbers have declined a bit, but we're still 72 strong. The engagement in the discussions were very lively. They were thought-provoking and soul-searching, and just what we need in a discussion like this. Thanks a lot to our panelists, Nicola, Lord Phillips, Stella, Joe, and Andrea. And I am really pleased that Garden Court and the Howard League have partnered on this very, very important issue that we face, and have engaged in such a way that hopefully we can present and throw out thought-provoking recommendations and opinions that will hopefully inform policy and undoubtedly influence further discussions on the issue as we work together towards reform. Hopefully somewhere back in the days when Lord Phillips started. Not hopeful about that, but of course we can but live in hope. Thank you once again, and I look forward to seeing you all joining us at another event with Garden Court.